So the right to confrontation comes from the Sixth Amendment to the United States Constitution. And it states that if you are a person accused of committing a crime, so a defendant in a criminal trial, then you have a right to confront the witnesses against you. And what that means is that you or your lawyer, if you have one, gets to cross-examine in court at your trial the individuals who are going to offer evidence that the prosecution is going to use to convict you. And the purpose for this right is really to prevent irrelevant, unreliable, hearsay evidence from coming in against you and improperly influencing a jury's decision. So think about a situation where a police officer or prosecutor could just take that police report with the officer's notes about different witness statements and just introduce that for a jury to consider. Now, what effect that would have is it would prevent you from being able to challenge the veracity or credibility or reliability of the statements in that police report. And so that's why this right exists, and it prevents that kind of conduct from happening. Instead, a person who was a witness or provided a statement to the police has to come into court and testify about what they actually saw or observed. And then you or your legal representative gets to challenge the credibility of that statement. So you get to cross-examine areas like somebody's bias for making a certain statement, any motive they have for wanting to get this person in trouble, their past statements, and if there's inconsistencies between their statements that they made previously and the statements that they're making at trial in court, and then any other relevant inquiry that goes into whether or not this person should be believed or not. So for example, a previous felony conviction as a good example of that kind of impeachment evidence. So there are some exceptions to this right, although they're limited. One is going to be any previous sworn testimony that was subject to cross-examination. So think depositions that occurred in the past. So if a person's been deposed and they had a legal representative there to do cross-examination, then the court's not going to require that happen again at trial. They can just accept into evidence the transcript from that previous hearing or deposition. That applies to previous trials as well for the same reason. Another exception is the ability to forfeit your right to confrontation. So if a defendant is the reason that a witness isn't there to provide evidence that the prosecution wants them to provide, then they can forfeit their ability to confront and cross-examine the witness that would be providing that evidence.